Okay, it's a great Monday. Happy Monday to you. Hope you had a wonderful weekend and that you're starting the week off great. If you're on the East Coast today, the business day is kind of wrapping up here. It's a little bit after 5 o'clock, but I know that some of you are probably still going strong. If you're anything like me, business hours don't mean a whole lot, but hopefully you can find some balance in that. That's what it's all about. But we don't want to take up a bunch of your time, but we do want to get you caught up to speed on what's been going on workerscompensation.com lately, starting with what you have to look forward to tomorrow. And what you have to look forward to tomorrow is a couple of features on the exclusive remedy provisions in different states and through different angles. First of all, don't forget that all these updates are brought to you by Simply Research. Simply Research is our encyclopedia of the workers' compensation industry, powered by workerscompensation.com, and especially the wonderful, diligent, hardworking compliance team at workerscompensation.com. Can't say enough about them. And we'll take a peek at what's new on Simply Research here momentarily. There's a 304. Basketball is happening, exciting stuff there. What a game last night with UConn, huh? Anyway, but here we go. This is what you can have to look forward to tomorrow. The thing that we're most proud of, that we're excited about, is our latest state snapshot from Chris Parker, where he covers the ins and outs of the exclusive remedy provisions under Mississippi workers' compensation law. So check that out. That'll really break down the basics so you can understand where Mississippi comes in on that particular legal topic and the cases that are on point. So you won't want to miss that. Some recent cases on point. Obviously, there's a lot, but over the past couple of years, these stood out to Chris, and so he dropped them in there. And while we're talking about exclusive remedy, the Alabama Supreme Court recently weighed in on a case that involved exclusive remedy in that state. And this one happened to be a Walmart worker who allegedly was jogging off the clock in the lot of the facility where he worked. It was a warehouse facility. A coworker and driving a tractor trailer ran into him with the tractor trailer while the worker was jogging. So after the worker obtained workers' compensation benefits, he then later brought tort claims against Walmart and the co-worker, and both of them failed on exclusive remedy grounds in the meta sense. The case against Walmart, the company, the employer, also ran into estoppel troubles, related to the exclusive remedy argument. He was saying he wasn't at work because he was off the clock exercising. And, if that was the case, that's, it makes sense. It's kind of a good argument. But the problem was he accepted workers' compensation benefits. So it was kind of like the court said, well, you can't have it both ways. That's the point of estoppel, is to keep you from trying to get remedies from both ways. You took the workers' comp benefits that Walmart gave you. You were perfectly okay to say that, yeah, I was working so I could get those benefits. And then you want to turn around and say, no, I wasn't working. I was off the clock exercising. So he kind of, was his own worst enemy in that case. And I should add that he was represented by counsel. So that was a key legal point here because he had an attorney. I mean, you could see a situation where, someone who's not versed in the law doesn't really understand, like, okay, the company's giving me money here because, I got hurt. And then later on, you think, well, maybe I could have gotten more money or something like that, if you don't know the ins and outs of the law. But he was represented by counsel, and his attorney would have to know that. And particularly because there was cases on point from the Alabama Supreme Court saying that, hey, once you take workers' comp benefits, your path to a negligence tort action is really a difficult one unless you've got some good theory there. So, when a party with knowledge of the facts makes an election, this is Brown versus six, and when a party and with knowledge of the facts makes an election between inconsistent theories of recovery, the election is binding. And so, they don't come right out and say it, but of course the attorney would know that if you're uh, claiming you're accepting workers' comp benefits. You're saying that it was a work-related injury. You can't turn around and say later, I wasn't at work. Anyway, so that's an interesting case. Something that's been interesting, and I hope you've been keeping up with it. The Batman villain case is kind of interesting just from the facts. That was another one that Chris put together for us. But one of the most educational things that we've had going lately is Dr. Claire Musselman's series on what you can call soft fraud, how things developed and how a workers' comp case might turn in directions that aren't great, and maybe, where there's kind of fuzzy areas on what's true and what's remembered correctly and things like that, in ways that you can keep those claims clean if you're an employer or a carrier. And the last one in the series is a 14-part series. I encourage you to go through there and read all of them. And at some point very soon, we will compile them into one place. But, for now, I want people to make sure that they get in there and read the articles that are useful to them. And I think all of them are, because at some level they get down to the role of good leadership in workers' comp, good leadership in organizations, and some best practices that everyone can engage in, especially employers. And this last one is no different. And so go in there and check out DCM's series here that we've dubbed the Workers' Comp Playbook, because she really spells out what you can do to make uh, claims cleaner. And uh, shameless plug. One of the ways you can do that is through our Simply Claims Kits product, but more on that if you read these articles. But the way to get to all 14 right now before we compile them together is just click on her name, and it'll bring back the list. And her most recent 14 articles are those play features. And before we leave, we do want to let you go here because we don't want to take up a bunch of your time. But don't forget about Simply Research if you want to check out and see what's been going on Simply Research of late, what's new. I can log in there, but you can get in there with a free trial. That information on the page we were just at, fill that out. We'll get you set up with 7 days on us for you to decide whether it be a good fit for you, and whether it will help you get your work done. We don't want to bug you about anything. We don't want to give you anything you don't need. We feel so strongly about it that we think if you just sample it, you'll see that it's well worth the cost there. So a couple cases went up. Some of our compliance summaries were updated thanks to our compliance team. And those are very helpful things. It's just kind of plain language, boils down a point of law to what you need to know. And then if you want to know more, or you're really interested in what the statute or the regulation says, you click on it, it brings it back there. So hopefully, if you go in there, you can find something that's useful to you, and then you can contact us and we'll get you set up with a Simply Research membership. But until then, please do take us up on that 7 day offer. You have nothing to lose. There's no strings attached. We promise not to bug you. We just want you to try our product because we do think it's a good one. And until we meet again, I hope that you have a wonderful week, or all the days between now and when we talk again. I hope are great. So thanks for stopping by. Thanks for being a part of what we do here. We appreciate you. Take care, everyone.